Hi, this is Josh Marshall, and this is the Josh Marshall Podcast with Kate Rika. We have probably going to have a slightly foreshortened episode of the podcast today. We're recording this Wednesday just after noon. We're going right into the Thanksgiving holiday. Probably a lot of you are traveling right now, so I guess it's now that I think about it, I guess it's possible that some of you will be listening to the podcast either this evening, Wednesday evening, or tomorrow when you're traveling to wherever your Thanksgiving family celebration is, or maybe when you're cooking or something like that. In any case, as you can tell, the domestic news has in a way kind of slowed down a little. The domestic political news, for understandable reasons, a huge amount of the space that is normally occupied by domestic political news has been taken up by the situation in Israel, Palestine, and Gaza, with everything that you know about unfolding there. As we record, we seem to be in this going into a multi-day process of both a temporary ceasefire and a mutual I don't want to say it's a mutual release of hostages, a release of hostages by Hamas, and a release of about three times the number of uh, Palestinian prisoners who've been charged with various, uh, you know, terrorism-related crimes in Israel. So that's happening. Um, and on the domestic front, as I said, things have there's not as much going on because so much of the national news is tied into uh, tied into the stuff happening on Capitol Hill, et cetera, et cetera, et cetera. But one thing we are going to talk about is we have yet another voting rights case that now seems like it will be percolating up through the courts. And I'm not even sure we can say deal another blow to the Voting Rights Act because it's kind of on its heels or on its back as it is. But another one has come up, and one thing I'm not sure how much play this has gotten in the coverage of this. Hard to say how relevant it is, but it's one of the widest uh, judicial districts in the circuits in this country. Obviously, the Northeast has a substantial African American minority population. A lot of the West Coast does, the South does, the Upper Midwest does. But there's a kind of if you kind of zoom in, sort of on the Mississippi River, the Upper Mississippi River, then up into the Prairie States, you can come up with a pretty white, in some cases, very lily white circuit, the Eighth Circuit. You got South Dakota, right? Now, in fact, the in the Dakotas, you actually have some. It doesn't tend to get a lot of attention, but you actually have some pretty real voting rights cases tied to reservations in those states. Years and years and years ago, I remember TPM. We covered very closely two Senate races in South Dakota, and there is a very similar story there about voter suppression on the reservations within the state. So it's very similar to what we're used to in many parts of the country with African American voters. Only it's Native American voters. So we're going to get into that, get into a couple other issues as well. But before we do, I want to remind you of something. This is sort of like one of those ads for ourselves, but it's an important one. So we are 1 year out from the 2024 election. And as you know, a lot of coverage of election news, political news in general, but especially coverage of elections in this country is very bad. It's not good stuff. We do it different. We cover elections the way they should be covered, and a way a lot of you would like to see them covered. So as part of this 1 year out period, we are offering a TPM election mega sale. If you subscribe now, you get 30% off an annual membership, and you are guaranteed to get our full coverage through the 2024 election. Everything that happens over the next year. So if you are a listener to the podcast and you're not a subscriber, now is a great time to sign up. Head to the site. You'll see ads for signing up as part of this mega deal. Maybe you used to be a subscriber and your subscription lapsed. Another really good time. Subscribe now. You'll get all of our entire year of election coverage. So stop by the site, sign up. 30% off right now as part of this TPM election mega sale. So, okay, Kate, what is this Eighth Circuit decision all about?
So the wonky term is this is about the private right of action, which basically just means that for the past, decades that the Voting Rights Act has been in place, people have interpreted it to mean that private individuals can sue under the statute. So the most often kind of arrangement we see are these kind of voting rights or civil rights organizations, NAACP or League of Women Voters, those kinds of organizations, coupling with one or a handful of individual voters to bring these racial dilution cases under the VRA to argue that a state is gerrymandering in a way to dilute the force of the Black vote. Usually, that's the kind of most common case like this. So the Eighth Circuit, following on the heels of this district court judge, which, surprise, surprise, a Trump appointee, as is the appellate judge who wrote the opinion, find that despite the decades of cases kind of built upon this assumption that private individuals can sue under this law, despite the Supreme Court pretty frequently kind of this comes up and they refer to it. They haven't had the question squarely before them, but they've kind of talked about it before. And you've got, a couple, you had Gorsuch and Thomas be kind of like, I don't think this is real, and sending up test balloons to be like, hey, right-wing litigants, you guys should probably do a case about this. But, the majority of the others have kind of referred to it in other cases, specifically a case about whether private rights of action existed for a different part of the VRA, and kind of rested their decision on their assumption that this is a thing under Section 2, so it's also a thing under Section 10. And then on top of that, you have congressional committees outright saying, when it comes time to kind of re-up the law, saying, by the way, Congress intended for this to have a private right of action. So, there's no confusion about that. Despite all of that, you had this one district guy and then these two guys at the appellate level, because for reasons we don't have to get into, and for potentially disputed or reasons that could be disputed, this case did not go up through the usual redistricting pipeline, which is a 3-judge panel with direct review to the Supreme Court. This one came up through, the more kind of the way that most cases are these days, which is one district judge up to an appellate panel. But, all told, that means you've got 3 guys who have said, forget about all these cases, forget about the Supreme Court, what they said, that's just dicta. Forget what Congress said. You can't really trust legislators. All that was wrong. We're the only ones who have it right. No private cause of action. And in fact, the only singular person who can bring Section 2 VRA cases is the U.S. Attorney General. That's it. End of list. And then practically, I've been kind of struggling to call up. This is a worst time for reporting in the whole entire year these days before Thanksgiving. But talking to voting rights people who are saying like 98% of VRA cases are brought by private litigants. I talked to one guy who his name is Doug Spencer, and he runs the All About Redistricting page, which is this really kind of valuable consortium of all the various redistricting news going on. He said they're tracking 200 cases, all just from this most recent cycle. 3 of those involved the DOJ, and they didn't bring the case in any of them. They just joined later, just to give you a sense. And that's under a Democratic administration, right? Like we're talking about 5 guys, gender inclusive guys who are working in the voting rights section of the DOJ who are in charge of all of this. I mean, under a Republican administration, there would be no such cases, right? It would crash to a halt. So the practical effect of this would be this last kind of remaining piece of the VRA that continues to be a weapon is just taken away. It's just that's kind of the
And let's
end of
be
it.
clear, what is Section 2? What is that piece?
Section 2 is the piece that talks about the vote dilution cases. So that's the part of the law that, now that the Supreme Court has kind of gotten rid, for all intents and purposes, gotten rid of preclearance, right? That used to be a really strong part of the VRA where, areas that had history of racially discriminatory voting practices had to get any changes in their voting laws passed with the DOJ before they could put them into effect. That's gone. So that has left the Section 2, these vote dilution cases, as like the biggest remaining weapon to kind of fight gerrymandering, particularly because the Supreme Court has also said federal courts cannot hear partisan gerrymandering cases. So all that's left on the federal level are racial gerrymandering cases, and this is the way that people bring those cases.
And by dilution, generally, we mean basically spreading the minority voters out amongst a lot of different districts, so they don't really have any substantial power in any of those individual districts. That general
Right.
idea.
The kind of shorthand is, cracking or packing, either spreading them out so thinly that their vote is kind of dissolved amid all the white leaning vote, or packing them all into one super D plus 35 district, so they can't affect the vote in any other district, to try to curtail the losses. So that's where we are. I've surveyed a lot of people. People are pretty confident, even given this Supreme Court's history on the VRA, that this decision wouldn't stand, because it's so out of left field. It's so kind of made up out of whole cloth, despite the fact that it's not like this is a question no one's thought of before. It's been clearly kind of percolating, even if there isn't a lot of precedent kind of squarely addressing the question. Due to a separate case from a few weeks ago, there's now like a circuit split with the Fifth Circuit, which is funny because that's the one we always think of as like the hotbed for legal conservatism, and they actually decided the other way. So
Oh, interesting. Okay.
but that brings me to an important point with this Eighth Circuit case, which is the Trump district judge is the one who introduced this question into the proceedings. Like neither of the parties had raised it independently until he raised it by himself, and then ultimately dismissed the case on his finding that you can't bring private litigant lawsuits under Section 2.
Is there? I know that sometimes in legislation it will say explicitly these kinds of litigants can bring a case. Is that what uh, it's clearly assumed since there have been updates of the VRA and it's always been this way. So if there was like some misunderstanding, if it were the case that Congress didn't think there should be private litigants, it's not like this hasn't been revisited since 1965.
Yeah.
So
The reality is it doesn't say explicitly who can bring them.
so
Go ahead.
I'm curious there though, if I would assume it came up in these arguments in whatever this opinion was, that there is some default that if it's not addressed explicitly in the legislation, that it just is automatic, that anybody can bring a case within the law. Is that what is the case law or established procedure, and what argument did these I guess it's not even litigants, since as you said it was basically the trial court judge just deciding it on his own, so in a way he's like the litigant, but what arguments were made within case law, precedent, et cetera, that they argued allowed them to make this, make this finding?
I mean, the short answer is they say the silence means that this practice isn't allowed. And extrapolating further, it's only explicit about the USAG kind of elsewhere in the statute. So bada bing, bada boom, that's what the silence must have meant. And in this kind of thing, when a statute is silent, even that is kind of, it's freighted, right? Because this, especially amid this conservative legal movement, they often claim statutory ambiguity as kind of the way in for weakening agencies, or making regulation toothless. But in this case, it's not like it was silent. The law is silent, and people for ages have just been going back and forth, right? Courts don't know what to do about it. There's like all this conflict. There's this clear kind of naughty question. It could be interpreted either way. We just don't know, right? And then like that goes to the Supreme Court, and they kind of settle it, which is why in this case, even though there's not a ton of kind of explicit case law on this question, that's where you have this whole kind of body of, well, we've been doing it this way for a million years and no one had a problem with it until now. So that kind of stands in for it. The one of the judges, a Bush appointee on the appellate court, wrote in dissent, and his whole thing was like, yeah, I'd really rather not upset the apple cart without kind of substantive proof that this is creating problems, that it's creating kind of circuit chaos. And at that point, the Supreme Court should decide it. So I would just leave things be. And then if the court kind of wants to take up this question, let them.
Yeah, because it's on its face, and this is clearly the point for the Trump appointees here. Clearly, this has really dramatic effects because with the numbers you noted before, virtually all cases are by private litigants. So it's not like this is just a small housekeeping thing. This has huge effects, and it seems like even the judges themselves were clear that there's really no evidence this is a problem. It's just not explicitly stated that it can happen, and because of that, the fact that it's been universally assumed forever that should have let me when you said at the beginning 2 Trump judges. That's because it's a 3-court panel, and that it was 2-1, I guess, at the appellate, and this Bush guy
right.
was the one who was in dissent.
But the Trump judges I was referring to is, you have the one district guy is a Trump judge, and the one on the appellate court who wrote the decision was a Trump judge, but then he was joined in that decision by a Bush appointee. So the appellate court had 2 Bushes and 1 Trump on it.
Got it. Now, does this have application? I mean, there's Voting Rights Act isn't the only federal law that has private litigants. So is there some question that this could open up all sorts of other questions? I mean, I don't think it would be a bummer for them, because this sounds like part of their whole anti-administrative state
right
thing, that you don't have like, do-gooders,
right.
lawyer do-gooders like messing everything up all the time.
That has not really come up in my conversations, or I think this might be more specific to the VRA. But one interesting wrinkle here is one person I talked to said there could be a potential workaround here, which is Section 1983, which our wonkiest minded listeners will remember from when I was doing a lot of reporting on that Talevsky Supreme Court case that dealt with whether beneficiaries of Medicare could sue under that law when their rights are being neglected. That is a general right of action. And so it's, in this case, like that as an enforcement mechanism would not necessarily be, it's not written into the VRA, but there could potentially be a workaround where you say, my rights, my constitutional rights are being neglected, denied, violated by the state. Therefore, under color of Section 1983, I can bring this lawsuit and kind of perhaps do a workaround without the VRA if this were to stand. Now, there, obviously, we just had this big Supreme Court case where you had, some, not to the extent of other cases, but some kind of right-wing actors trying to get rid of that right of action. So it's not to say that anything would kind of be safe in this landscape, but in terms of other laws that could be kind of roped into this, you can bet that, if this were to stand, you would have kind of voting rights and civil rights groups start getting creative, trying to find like other mechanisms, even though they would obviously be bringing those claims in an increasingly kind of hostile judiciary to any sort of minority voting right protections.
And just for our listeners, when we say private litigants here or private action, we're not talking about like just like Fred thought something was wrong. Generally speaking, we're talking about like the NAACP or like a state Democratic Party, right? I mean, we're talking about, these are generally non-government organizations that
Right.
are the ones who bring this up.
And the thing, that is so kind of crushing about that is, as it is, these VRA vote dilution cases are like super expensive. It's a really, really onerous thing to prove because there are these preconditions you have to satisfy, and you have to go deep into the demographics of the state and the history of the state. And so, as it is, when VRA cases get brought, it's nearly always about the most egregious, flagrant kind of weakening of minority voters' power. We already are nowhere near kind of the edge of cases that, maybe you'll win, maybe you won't, might as well bring them. Basically, everything that's getting brought is like a slam dunk because of the expense, because of the fact that, the defendants in these cases are like voters, and the people bringing the cases for them, as you say, are, NGOs or just kind of do-gooder, good government organizations, which tend not to be like flush with money, right? So as it is, we're only getting cases where it's just like undeniable kind of state malfeasance. So any kind of idea that, there's over enforcement of the VRA is just like nowhere near the reality.
Right. And just to, we sort of alluded to this at the beginning of our discussion here, but among everything else, it basically means there will be no Voting Rights Act unless there's a Democratic president. I mean, like in theory, if something like this were to succeed, you could, like, a Democratic president could say, all right, we're going to hire like
Right.
100 lawyers for the vote, for the Voting Rights Division, and just kind of like take this on ourselves, but nothing under a Republican president, given where the Republican Party is on this stuff now.
And there's the additional wrinkle that should this, a two-part wrinkle. The first part is we're currently having a lot of these really intense redistricting legal battles upon which control of the House in 2024 like may well rest. So there's no chance you're not going to have, Louisiana or Georgia or some of these like particularly red southern states who are fighting tooth and nail to not have to create another Democratic seat. There's no way we're not going to have them, if they haven't already, file being like, hey, look at this decision. Like, this lawsuit was invalid in the first place. And at the very least, you should pause all this stuff until that's sorted out, which is going to take years, right? Which would help them kind of kick the can past the 2024 election. And then the second part of that wrinkle is, what about the cases in the last few years where the voters have kind of won their VRA cases? Like, you're definitely going to have a lot of those, the people on the other side of those cases come back to judges and be like, well, are you going to vacate this? Are you going to remand this? Like, this lawsuit was based on illegitimate grounds. So, there's just this whole tidal wave of chaos that it would be unleashed, which is kind of part of why a lot of experts think that even in this court, which is generally so hostile to voting rights, the Supreme Court, that this is one they might not want to touch because it's so flimsy, it's so like rootless, and it would just have these really far-reaching effects that would have visible kind of countrywide chaos.
But to your point, help me understand how this plays out in 2024. Is there, well, first of all, at the moment, this only applies in the Eighth Circuit, right?
That's right. So only to the states that the Eighth Circuit governs.
And the Eighth Circuit does not include, I mean, not like it doesn't matter in the Eighth Circuit, but the Eighth Circuit, I believe, is what, Arkansas, Missouri, up into the prairie states, kind of this group of states, sort
Mm-hmm.
of along the upper Mississippi River Valley. Um, is it, but in terms of it being reviewed in the Eighth Circuit, that it's not like the court is going to just like step in immediately. This is just going to be in the normal course of if they decide to take it up in the next calendar year.
Right. A few things could happen now. The Eighth Circuit might even hear this case en banc, which means, the whole circuit versus just this panel. And some experts think if that happens, it'll probably get overturned at the Eighth and not even get to the Supreme Court. But if the Supreme Court were to take it up, it just like no chance it would happen pre the 2024 election for them to kind of take it up and get it on their docket and have it scheduled before then. They don't tend to move that quickly. So like you said, right now this just governs the states under the Eighth Circuit, which I have to double check, but I'm almost positive none of those states were pre-clearance states back when that existed with the VRA, which, as you say, demographic makeups just make those like not the kind of hotbeds of minority voter suppression, though of course that exists everywhere, but not to the extent that the South is. Like that's where kind of
Right.
all of the ongoing action is happening. So that's where we are right now, and I think the bigger picture thing here is just this is such a continuation of themes that we've talked about on the pod and that we've seen ever since Trump's election, which is you've got the far right justices on the Supreme Court sending out the bat signal, telling litigants like, hey, I would be open to hearing a case about this. You've got these Trump appointees who are super comfortable breaking from precedent and kind of handing down decisions that favor their partisan priorities without much bothering about rooting those in a rigorous defense. And you've got, like Professor Spencer, who I mentioned earlier, just made a really good point on this front that it's like this decimating of what scant minority voter protections we have at a time where our country is so openly embroiled in warfare about whether we're going to keep this kind of liberal democracy with minority rights and an enfranchisement versus if we're going to kind of let it slide into this authoritarian system where voters are gerrymandered out of relevance or voter suppressed out of relevance. And it's just, this case is just such a good microcosm of all those kind of bigger dynamics that are straining our country right now.
So that's a good segue on the broader question of authoritarianism. We have an ongoing litigation about the gag order of President Trump tied to his January 6th trial. What's that about? Why? Who has intervened in that case?
So this was like a branch off that main trial, which is about his culpability in January 6th. And this isn't the only one of his many cases where this is coming up, but Trump's predilection for like not only kind of posting to a deranged degree about these cases he's involved in, but singling out these often really kind of anodyne individuals who are like related to the trial, but aren't, in kind of nondescript ways. Like obviously you have him going over after the judges and the prosecutors, but, we just saw in the New York fraud case, he picked out the poor clerk of the judge and called her Schumer's girlfriend and all this kind of, and decided she was running the case against him. But anyway, all that kind of stuff is now creating in multiple of his cases these tangential whole, arguments, briefings, the whole 9 yards about whether or not he should be put under a gag order, what the parameters of that gag order should be, and the valid questions of you got to be careful with the rights of criminal defendants, right? Because they're already not just Trump, but in a general genre, you've already got those people who you're freer to take rights away from than you would with other people. So I think there is like a good faith reason to want to tread carefully here. And then Trump just makes it farcical, right? Because it's like he'll have a gag order lifted by an appellate court and then go on a tweeting spree or a truth socialing spree. And in this January 6th case, it was actually 3 appointees by Democratic presidents, 2 Obamas and a Biden, who was debating this on the DC circuit. This lower court judge had put a gag order in place, a very honestly circumspect one, where she said, basically you can't like rile up your supporters to go like kill people involved in these cases, but you are free to pontificate about the unfairness of it all, the political machinations, the deep state at work, the Joe Biden just out to silence his whatever. All that is fair game. You just need to stop finding poor like staffers and saying, well, she's sleeping with Schumer and she's the reason why I'm in this mess, right? So the circuit was honestly, you could tell, extremely torn. Like they beat the Trump guy to a pulp because the Trump lawyer is saying he should have no restrictions on his speech whatsoever. He just by virtue of the fact that he's a candidate and the American people deserve to hear what he's saying, and like we need to be even more careful with his rights than usual because he's running for office.
So they're hanging it less on just you shouldn't the bar should be very high for surrendering rights before you've been convicted of anything. So sort of seeing him through the prism of he's just an unconvicted criminal defendant, and he's the issue, not the rights of his supporters and the election. They're very much hanging it on the election. That we have an election, and this is compromising the election.
Exactly. And keep going back to this argument of like, well, Trump's not responsible for what his followers do, which, as we have seen from the various kind of litigation post January 6th, like that is a genuinely hard thing to prove in a court of law, that even these like inflammatory things, if they fall short of Trump being like, I want you to Rambo up and go to this person's house. It's like, it's hard to prove that that's what kind
Right,
of,
right, right.
so anyway, they kind of beat Trump's guy to a pulp and had a lot of quotes about, it's very obvious that you are not at all concerned about a fair trial, about, kind of keeping the proceedings as clean as possible. But then when the government lawyer got up, it was kind of the same treatment, like very hard, a lot of hypotheticals, a lot of things as granular as like, would this Trump insult be okay with this gag order or would it not? A lot of back and forth about Jack Smith, the special prosecutor in particular, because does he count as the staff members who they're trying to get Trump to stop like endangering, or he's this high profile guy who agreed to do this job, so does that put him more in the venue of like a public official who can be kind of expected to get more flack than your normal person who works at a court? So I kind of came away with the conclusion that I think probably the gag order, some version of the gag order, will stand, but I wouldn't be surprised if they kind of narrow it even further from what the district court said. And that brings up this bigger question of like, is the judiciary in a fit state to kind of defend itself from Trump? Because, the thing that makes all of these proceedings so surreal is, like, as we said, there are really serious legal questions here, and you don't want to just strip criminal defendants of their rights willy-nilly. But Trump is this singular figure who's got masses that he can activate, and that which we've seen be activated, right? Like he'll post about these people and then their courts will get death threats. I mean, it's all tied into the same fabric that kind of left Paul Pelosi attacked in their home. It's all the same thing. And it's this weird dance where like Trump is a normal person and you have to treat him like that, but he's so much more powerful than a normal person, and like that has to enter the equation. And it's also part of this thing we've been talking about forever, which is, why would Trump stop running for office when the fact of him running does afford him, not like an explicit legal protection, but it gives everybody this queasiness about not, curtailing his rights and not skewing the election.
Yeah, I mean, one thing, when you dig into the legal specifics of it, um, there are there are real issues, right? Um, at the same time, I think we at least have to start with the unquestionable reality. It's a little different in that New York case, since that's not the people being criminal defendants. So I'm not even sure they could remand him in that case. In that case, it's a criminal trial against the company. Am
Yeah,
I
that's right.
remembering this right? And so in that case, he is not a criminal defendant. The company is a criminal defendant. But in these ones in which he is a criminal defendant, there is no question anybody else on facing felony indictments who is out there saying the judge is a lying sleazeball and deserves to be hanged or whatever. Man, you are in jail so fast. It's not even funny. I mean, not even like you don't even in just the way that criminal trials work in this country, you don't need to construct an argument. Well, okay, how is the defendant saying the judge should have her head cut off? What's the nexus between this and her head actually being cut off? Man, no way, no way. You just get in the judge's face like that, you're done. You're going to spend the entire course of litigation behind bars, and maybe that's a little problematic in itself, but I think we have to recognize is that when you're indicted, you lose a lot of rights to start with. I mean, the most obvious of which is that if the state can just show there's a chance you might flee, you got to be in prison. That's a huge right. That's a huge right to to lose right there. Um, and it's certainly true that to the extent that he is arguing that he's being persecuted, that someone who is making such an argument should be allowed to continue to make their case. And one could imagine in that case if Trump was saying, well, it's such a hard hypothetical to imagine Trump speaking publicly with some sort of maybe poor rational case, but making an argument, as opposed to these kind of just like florid, over the top tirades. It's yet another case where our system is not really equipped for someone who's so over the top and out of control as Trump, or maybe to put it more accurately, someone who plays over the top as part of his modus operandi. I was actually rereading some stuff about, this is kind of sound kind of random, William the Conqueror, right? The Norman Duke who took over England 1,000 years ago. And a lot of questions about how he was able to make that stick over time. And one of the best arguments is that he just didn't follow any of the rules that, let's put it, for lack of a better word, the norms of early medieval chivalric Northwestern European culture. And he was willing to commit levels of violence that were way over the top, even by the standards of that period, which were pretty flexible when it came to killing people, right? And there's a very good argument that was the people were not prepared for what he was willing to do, and that gave him this kind of built-in advantage. And when I was reading this, I was almost sort of like, wow, this is kind of think we've heard this sounds familiar, right? And we know that whole norm busting thing that ever since the 2016 primaries, when he was operating, and in that early stage, it was to a real extent not like governing norms, just campaign norms. How do campaigns work? and he was able to move so much faster and operate in such a different way that the more traditional campaigns didn't know what to do with it. So, we're seeing that again here. Why would we be surprised? Of course we are, right?
Yeah, that's a really great point. So you do it, just before we move to our last topic, you gotta almost hand it to him in terms of his total willingness to like just shit all over like the person who is in charge of deciding like what his sentence will be, and I know there's like, oh, it's because he never faces consequences and blah blah blah, and it's all tied into the stuff about how he's bad, but it's just like crazy to kind of go before a judge who holds your entire fate in his or her hands and then go home and like whip out your phone and be like, that guy's a dick. It's just like, oh my god, it's just
No, but well, I guess there's two parts of that. One is that, as we can see, he's able to go so over the top and be in such a unique position, one he has created, that somehow that becomes, and it even becomes to the people who are his targets, the judges, somehow it becomes their problem rather than his problem,
yeah,
because now they need to make really clear that the fix isn't in, or really really clear that that they're 100% being fair and not anti-Trump. And as we know, that's one of his superpowers, is to, yeah, after you say that the judge is a worthless drunk and a fuckhead and a sleazeball, yeah, they probably are pretty anti-Trump because you suck. You're like, you're treating them like shit. But that, again, somehow becomes his advantage. And but I think it also reflects something more particular in this case, which is that he's got to figure, if he's going to wriggle his way out of this, it's not going to be through the normal process. It's
right,
because he is elected president and he makes it all go away, or he isn't elected president, but he just keeps it bottled up and appeals till he dies or whatever. I mean, he is clearly written off the option of going before the judge and expressing remorse and saying, "Judge, can you cut me some slack here for old time's sake?"
right,
That's not what he's going with.
yeah. Okay, so let's round it out with something a little more lighthearted, e.g., the House Ethics Report, which came out late last week, but after we'd recorded, and detailed the many, I don't even know what to call them, the many weirdnesses and crimes and assorted misdeeds of George Santos, who has since announced that he will not run for re-election, to the crushing disappointment of his constituents. Um, this report was
You-
so weird. Did you read it?
I did not read. I read a
You
few
read
parts of it,
reports
and
of
I
it.
read the rundowns of it.
Yeah. It was so like I think the thing that struck me is he engaged into so many behaviors that it was inevitable that he would be caught doing. It's not like there's some stuff in there that you can see, okay, there might be a long game here, like that he clearly thinks he can kind of get away with shifting money around between his like his fake firm and his FEC accounts and his personal account, and like a lot of it is just shifting money between those things and then putting them into his personal account so he can like pay for all the attention grabbing parts of the report, the Botox and the OnlyFans and the Hampton vacations and his entire honeymoon and everything like that. But there are parts, especially when the kind of investigators get involved, where they said, who is your like tax preparer, right? Like, we need to kind of talk to that person. He's like, oh, it's this woman. So they go and talk to the woman and she's like, no, I'm not. Like, I don't know what you're talking about. Like, I didn't do his tax. Like that kind of stuff where it's like, obvious he's going to get caught, right? It's not like they're not going to follow up on that. But he,
Yeah,
at every step, it'll just be stuff like, you know what? Okay, I'll send you those documents by the end of the day. Don't send the documents. And then it's like, oh, I'm straightening these two things out and then I'll send them, and doesn't send them. But with the only exception to that being the part that the House Ethics Committee was not able to substantiate, which were allegations of sexual misconduct from someone who had, I just think, interviewed for his office. I don't think the person was actually hired. And in that, the investigators say he was a perfect cooperator. Like he was responsive. He handed over all the documents that they wanted, and then they kind of conclude that section saying, like, just to be clear, we're not trying to say that he's a good person. We're saying this is kind of further proof that when he thinks cooperating is in his own interest, he is capable of doing it. Right.
Well, as we know, in many cases, certainly if it's only interviewing for a job, there may not be any evidence. When you're an employee, there's that will often generate paper, or you have coworkers or whatever. So it's certainly plausible that whoever the accuser was, it was valid, but there just wasn't any. It was just two conflicting testimonies.
Yeah, it reminds me of, I don't know if you've watched that like Netflix fictionalization of the Anna Delvey story. Is she's
I
one of
haven't.
Okay.
Yeah, but I know what you're talking
It
about.
came out of a, I think, maybe Vanity Fair or a cut piece, but it's all about just this woman who kind of was this like almost incredibly effective operator in New York in terms of like taking advantage of rich people, and she had nothing to back it up and everything like that. But part of her story, both in the article and the fictionalization, is just like, there's a point where she's reaching the end of the road, right? Where like too many people are paying attention and too many powerful people are paying attention for her to get away with this for much longer. And it's almost this frantic sense of like operating at like hyper speed to put off the reality that there are going to be consequences and just still try to find a way to burrow out of it even when the net is kind of tightening. And that's
Right.
exactly the sense I got from this report, right? Like in those early days, it's like big loans to himself, and like when staffers bring it up, he's like, oh, don't worry about it. And then when outside entities start to get whiffs of this, he's like, it was the treasurer, it's the crooked treasurer, right? It's not me. And then as they start getting closer and closer to the end of this process, it's just more of that kind of like frantic, like, no, that was this red herring, like trying to kind of obfuscate to avoid the consequences. And it's weird because you can never know about the psychology of this person, right? Like there's clearly a lot of weird shit going on for one person to have generated this degree of lies and schemes, and all in the service of kind of self-aggrandizement. Like there's obviously something psychologically loose there. Most people don't do this kind of thing. But I was just like wondering, like, do you think he's internalized the fact that he's going to prison when all is said and done?
When he announced he was not running for reelection, that was the first time I kind of thought like, okay, maybe there's some realization, but like it's remarkable that he has sustained this till now, because I mean, rationally speaking, that was pretty crystal clear in January. Certainly by February and March, I don't remember when we first got sort of um, concrete confirmation that there was a federal investigation. But I mean, he's still been out there talking about his reelection campaign, talking about his fight against the deep state, just like, dude, wait, don't you know you're going to prison? You know, don't like he does have, sort of like Trump, one of these reality distortion vortexes around him, where you hear him continuing to play it straight, well, play it not straight, but play it like it's like none of this is happening, that you're watching, you're like, wait a second, maybe is he not going to go to jail? Is he just going to keep being a congressman? What you described there about, just the, obviously someone can commit an organized system of financial fraud for a fairly long time, at least until people, before people start looking really closely. But as you said, some are like, don't, if you're gonna like use your campaign contributions for Botox or to whatever, go on vacation with, that's gonna catch up with you. And it's funny, it sort of reminds me that these are the kind of things that people do when they have like a terminal illness, or they're about to like uh, go on the lam abroad, disappear, and they're kind of like, buying stuff on the company credit card and doing all sorts of stuff because it won't catch up with them because they're heading out either in the great cosmic sense or, gonna go set up become a warlord in Libya, right? One of these two things. But here it's clearly characterological. And there was two, before we finish up here, two big mistakes. If he would have just, in the week or two after that first article ran in the New York Times last December, almost a year ago, if he just would have said, I'm resigning, this was a bad idea, he probably would have not, I doubt he ever would have been investigated. Just because it took a while for it really to be clear. It wasn't just like saying you hold the world record for the 100-yard dash. It wasn't just a bunch of nonsense. That there was like lots and lots of criminal activity. The other mistake was prosecutors always see it as a big thing of value if you'll resign from office. If you're a public official, an elected official, if you'll resign. So that's a big chit to hold on to in plea negotiations. That's something you can give up and get a much lighter sentence. But at this point, it seems highly likely he will be expelled from Congress in about a week. So if you're the prosecutor, you're like, why would I give you something for that?
Right.
You're toast in a week. I'm just gonna wait. So for everybody who kind of has grumbled that why aren't there consequences, just wait. He's stacked up a lot of consequences for himself.
Yep. All right.
All right. Well, that is our abbreviated. It actually turned out to not even be wildly abbreviated episode right before Thanksgiving.
We're so bad at abbreviating ourselves.
Yeah, we do. We are bad at it. So if you're listening to this tonight, Wednesday night, or tomorrow, traveling to your Thanksgiving dinner, have a great Thanksgiving. Have a great Thanksgiving weekend with your family or whoever whoever you are sharing it with. And remember, we have this special deal right now. You can sign up for a TPM membership, an annual membership, take you right through the 2024 election, whatever comes our way, with our special, unique, and non-crappy way of covering elections. And if you do that right now, you get 30% off. Just go to the site. You'll see ads for it. Sign up now. Take you through the election, and get a really nice steep discount. And that's all we have for this week.
All right. Well, we'll see you next week.
See ya.
The Josh Marshall Podcast is hosted by me, TPM reporter Kate Riga, and TPM founder, editor-in-chief Josh Marshall. The show is produced by Jackie Wilhelm. Thanks to Why Not Jansfeld for our podcast theme song, and thanks to all our TPM members who make this possible. Rate and review us on Apple Podcasts, and subscribe wherever you listen.